The Verania versus Action was about the school Verania wanting to drug test James Action because the school was told that there were athletes doing drugs. James had to fill out a paper that said that the school could drug test him before he started his football season. James Action and his parents refused to sign that because James had never had a history with drugs, therefore he shouldn't be tested for it. His parents believed that by doing this drug test, that it was violating his 4th and 14th Amendment rights. When the school wouldn't let James play sports because he wouldn't sign the paper to do random drug testing, his parents took the issue to court and filed a lawsuit. They said that it violated James' 14th and 4th Amendment. When they took this case to court, the Actions lost their case, and the judge believed that it didn't violate James' 14th or 4th Amendment rights. The Actions appealed, and they won the next case, but the school then appealed against that and took it to the Supreme Court, where the Supreme Court ruled that the Verania School District drug testing of the athletes was reasonable under the 4th Amendment.
The part of the Constitution that the Verania versus Acton case violates would be the 4th Amendment and the 14th Amendment. The 4th Amendment states that it prohibits unreasonable searches and seizures and requires a warrant, which means that you can't search anybody without a warrant. And a warrant is a piece of paper that shows that you have the authority to search their things, or in this case, search James Acton for drugs. The 14th Amendment states no state shall deprive any person of life, liberty, or property without a due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. To sum up, what that means is that the school cannot search James Acton without a warrant or his permission.
This case first came from a small federal court, and it was about James Action and how the school wanted to test him for drugs. James and his parents filed a lawsuit against the school and took it to court. The Actions won the first case, but then the school appealed to the Supreme Court. When the Supreme Court accepted the case, the vote was 6 for the school's idea of drug testing. Students before entering a sport, and 3 voted against that idea. Therefore, the school had won the Supreme Court case with some expectation. The school is allowed to have some reasonable random drug tests if they think there's a drug problem. Now schools have random searches and drug tests to protect their school and the students in school.
The decision of this case was that in the Supreme Court, the Vernonia School District won the case. The decision outcome was 6 for Vernonia School and 3 for James Acton. A quote from the majority decision side was, writing for the court, Justin Anton Scalia said, "The most significant element in this case is that the policy was undertaken in furtherance of the government's responsibilities under a public school system as guardian and tutor for children entrusted to its care." He pointed out that when the government acts as a guardian and tutor, the relevant question is whether the search is one that a reasonable guardian and tutor might undertake. And he concluded that given the mission of public schools and the circumstances of this case, the searches required by the school board's policies were reasonable and thereby under the Constitution's 4th Amendment. Therefore, that gives them the right to drug test them when they participate in after-school sports. This decision impacts modern law because it gives the school the authority to do drug tests if they think the school has a drug problem. The schools only do this to keep the school and the students inside the school safe.